Welcome, viewers. I'm Bill Bronchick, and this is a special Sunday evening webinar I decided to do this morning. It just kind of came to me like a bolt of lightning after I got about 4 or 5 emails in the last 2 days about this topic, and I said maybe I'll do a presentation on this. It's going to be about 40 minutes or so on the ins and outs of buying subject to. 7 valuable tips for doing it. I think a lot of people have a basic knowledge of what a subject to is, but they really don't know how to execute it or execute it properly, or they just don't have enough knowledge to get the confidence to do it. So hopefully with this webinar, you will get the knowledge and the confidence you need to go ahead and do deals of this nature. So let's look at the harsh reality first. People are sick and dying, unfortunately, all over the country. Hopefully things will get better soon, but there's also an economic mess that we have to deal with. It that businesses are shut down, from restaurants to gyms to retail stores, and a lot of people are suffering economically, and a lot of those people who have businesses that are shut down own homes. You know, they say unemployment could reach as high as 30%. I think when the numbers come out at the end of this week, it's going to be pretty close to 19%, which is pretty darn scary. It's going to be higher than the Great Depression. Tenants can't pay rent in a lot of cases. Houses aren't being shown, although in some states they're starting to open up a little bit. You can't do open houses, and people are just fearful anyway. You get a lot of buyers who are skittish about maybe buying a home because they're afraid of the economic future, and they may lack the credit to be able to purchase a home because a lot of banks are tightening up. As you may have read, Chase is going with minimum 20% down. Both Chase and Wells Fargo have cut off all new home equity lines of credit. So there's a lot of suffering that's going to go on in the market. And lending has pretty much ground to a halt, just understaffing, back processing. Appraisers can't get out and appraise, inspectors can't get out and inspect, underwriters are backlogged. So it's going to have a pretty harsh effect on the economy and the real estate market. So you're wondering, is the real estate market going to crash? Yes, no, maybe. Well, I think it depends on the neighborhood by neighborhood places you invest, but I think overall, this is what we're looking at. Supply is still low in most markets. The number of homes for sale is very low. Now that number is going to change a little bit. Some sellers may just take their houses off, but a lot of people are going to have to list their houses because their business just went out or they just lost their job. So that may increase a little bit. Demand, however, is going to drop temporarily. Depending on your local market, anywhere between 6 months and 2 years, demand is going to drop off for the reasons we discussed. Inability to qualify, skittish about buying a house, not sure if they should wait, not sure about interest rates, not sure about the future. And as a result, houses are going to sit longer than normal. And that's going to create some motivated sellers, and prices may flatten or even drop dramatically in some areas and in some price ranges. Now, the good news is prices will come back, and then some. In some areas, maybe in 6 months to a year. In some other areas, it might be as long as 2 years. In the Northeast, oh boy, they may be in for many years of pain from this debacle. But if you've been complaining about prices being too high, now may be the time that you're looking for to find the bargains. There's going to be a window of opportunity, not as big as the last time around from the 2008 crash, but in most markets, 6 to 12 months maybe before things start to recorrect themselves. So don't sit on the sidelines, get into the game. If you've been looking for that opportunity to find bargains and complaining that house prices are too high the last 7 years, this may be it. As Sun Tzu said in The Art of War, in the midst of chaos, there is also opportunity, and there certainly will be opportunity amidst this chaos. And by the way, do not feel guilty about the idea of looking for homes at bargain prices or looking for deals amongst the economic pain and suffering that people are experiencing right now. First of all, there is nothing wrong with looking for investors' opportunity when things are bad. Unless, of course, you're a congressperson, you're not supposed to do that, but we all know that. But they're on the inside. Number two, you are helping people. You're helping people out of bad situations who are facing potential foreclosure, losing their home, their credit, and maybe even becoming homeless. You are preventing neighborhoods from becoming blighted. If investors like us didn't exist, with all the foreclosures that are going to be coming over the next year, there would be basically blocks full of houses that are boarded up because nobody's buying them. So we do a good service for people, for neighborhoods, for the community. Do not feel guilty about the idea that you're a vulture or something like that, or taking advantage of people. You are absolutely not doing that. Real estate is about solving people's problems. I've always said this, and some of you who have been to my webinars and seminars heard me say that there are two requirements that I have on every deal. And number one is that I help the seller out and to be in a better situation than I found them. And number two, I make a reasonable profit. And both of those are required on a deal. I mean, you don't want to do a deal just for profit and put someone in a bad situation or worse situation. And you don't want to help someone out and lose money. That's charity. You can be charitable in other ways with your money and with your time, but don't do it with a house just because you feel bad for somebody, because then someone's going to feel bad for you one day as they take that house over from you, the motivated seller. So buying subject to is going to be one of the best strategies that you're going to have in your arsenal over the next 6 months to 18 months. And that is looking for potential sellers who are literally just walking away from houses, walking away from mortgages, walking away from equity, walking away from payments. And if they do nothing and you do nothing, they get foreclosed, they get thrown out, they get their credit destroyed, and you can help these people. You can help these people and you can make a profit. And that's the good thing about this business. So this is how a subject to works mechanically. The seller transfers ownership to you at closing in the form of a deed. What kind of deed? Depends on what state you're in, but generally a warranty deed. If you're in California, a grant deed. So what you're looking, not necessarily a quit claim deed, but a warranty deed, just like you would do at a normal regular closing, and you would do it at a title company, your attorney's office, or escrow office. You do not pay off the seller's mortgage at closing like you traditionally do. Traditional closing, the buyer comes in with cash, either in their own money or borrowed money, and the closing agent, the escrow officer, or the attorney doing the closing is going to pay off the seller's mortgage and transfer title from the seller to the buyer, record a deed in the buyer's name, and then if the buyer has a new mortgage, then a new mortgage to the buyer's lender. So we're not going to do that at closing. We're going to take subject to the existing loan, which means we're not going to assume the loan. Assuming means you call up the seller's lender and say, I want to take over liability for this note. Please put me on the hook and take the seller off. Now, why would you want to do that? First of all, you got to qualify for that, which you may not be qualified for. If this was a seller living there and you're an investor, they're not going to let you assume a loan that was meant for an owner-occupant, which is probably a lower interest rate, by the way, which is a big advantage to you as the buyer than if you got a loan yourself as an investor. We're going to take subject to the loan and keep making payments on that loan to the seller's lender as if we were the seller. The seller does remain liable for the mortgage note. Okay. When I say mortgage, by the way, I understand that in some states like mine in Colorado, Texas, California, we use something called a deed of trust. A deed of trust is a security instrument. It's a mortgage. It's a lien against the property for a note. It's not the same thing as a warranty deed. So if you're confused on that, don't equate deed of trust with deed. Deed of trust and mortgage are the same basic thing. The only difference is in some states they use deeds of trust, and in some states you use mortgages. The only difference is the way you foreclose it. And I'm not going to get into those intricacies right now. Save it for another webinar. But understand when I say mortgage, I'm going to use that interchangeably with deed of trust. So the seller remains liable on the note, which means if you don't make payments on that loan, it goes against the seller's credit. And if the property's foreclosed, the lender can go after the former owner who was the borrower on the note. Now, you might be thinking, well, who would want to do this? What seller would do such a thing, being liable for the note, but not be on title to the property anymore. Because if you don't pay, the seller is without recourse. He can't take the property back because he already gave it away. Okay, so you might be thinking, who would do such a thing? And you'd be surprised what people do in motivated situations. I'll give you a perfect example of one that works every day of the week and happens all the time, and it's been happening for 50 plus years. So husband and wife buy a property together. They're both on title and they're both on the mortgage. In a divorce, let's say husband agrees to give title to the marital property to the wife and move out. The husband has no longer has any ownership in that property, but he's liable on the mortgage note. So if the wife doesn't pay the mortgage, the lender can come after the property or the husband. It'll affect the husband's credit with late payments or bad payments or a foreclosure. So you're wondering, who would do such a thing? People do it all the time. People do this all the time. It's not that uncommon as you would think. And of course, the best part is you are not liable for the note. That means if you can't make the payments, it won't affect your credit. The lender can't come after you. Besides, when I say you, I mean not you, but an entity you would form for the deal. Okay, so I'm not going to get into the intricacies of that right now, of LLC, corporation, trust, and all that. That's another webinar we'll do. But understand that you're not personally liable, nor is your company, for the note, because you didn't sign the note. By taking title to the property, you get ownership, but you're not liable because you did not assume the loan. If you assume the loan, you're liable. If you don't assume the loan but take subject to, you're not liable for the note. That's a good thing, because if we go into a situation where we get another virus or something worse happens in the country and you can't make payments on this loan, you're not liable for it. You could just give it back to the seller, and, well, they may not be happy about that, but at least they're no worse off than they started. Okay? So very, very beneficial to you, the buyer. You're not liable. You're not qualifying for it. You're taking a property usually with a low interest rate loan, which we'll talk about later. Maybe has some equity in it, because remember, if the seller's been living there 8 years, there's only 22 years left on the note. You're not starting at 30 years, you're starting at 22 years, which means you're paying down equity. So very, very beneficial to you as the buyer to use this transactional method. As you may have surmised, not the best option for a seller, but if a seller is thinking, I'm going to walk and let it get foreclosed and who cares what happens, or just puts their head in the sand and doesn't make payments, you're doing them a favor. Especially if they're behind in payments, you're making up back payments, which means you're taking it out of default, which makes the bank happy, makes the seller happy, and you continue making payments on time, you're going to improve the seller's credit. You're doing them a huge service here. So don't think you're taking advantage of anyone. As long as you disclose all these risks, as we'll talk about in a bit, I don't see any problem with this. Now, those of you who've been around the block, and I see comments coming in already about the mortgage on the seller's mortgage has what's called a due on sale provision or acceleration clause. Now, what is that? Well, it's a clause in the mortgage, which is a lien against the property, and it says in the mortgage document or deed of trust, it says in the event that you transfer title, as I described, the lender may, at its option, call all sums due and payable, meaning immediately due, you have 30 days to pay it off or we'll foreclose. So let's read that clause again. This is referred to as a due on sale clause. And if you transfer the ownership of the property, the lender may, at its option, call all sums due and payable. Again, at its option. Is it really due on sale? No. It's due on sale if the lender chooses at its option to do something about it. So it's a contractual agreement between the seller / borrower and his lender, where if the borrower does X, the lender may do Y. But it's not automatic. And the reality is that most lenders don't care. They don't exercise their right to call the loan due. And for the last 30 years that I've been practicing law and investing in real estate, and as an attorney, I have to say I've done probably 1,500 transactions that triggered a due on sale, and only seen 2 lenders out of all those transactions make a stink. And that's pretty good odds. So the point is that, is there a risk the lender may call it? Yes. Is it a big risk? No. So why do the lenders even put that clause in the mortgage? Well, think back 1981. Interest rates are extremely high in the market, 12, 13, 14%. You take over someone's property subject to, which is 5% loan. Of course, the lender is going to exercise that due on sale. They're going to call it so they can refinance that loan at 13 or 14% and get rid of that old 5% loan they're losing money on. But interest rates have been pretty flat or falling. And in the near future, there's no indication that interest rates are going to go back up to 13%. If they do, will lenders start calling loans in the future, like down the road, years later? It's possible, but not likely, especially in the short term. So it's a risk-reward thing. And again, if you're putting up a minimal amount of money on a deal, what do you have to lose? If the lender calls it, you just give it back to the seller and say, thanks. I mean, you can only lose what you put up. It's not your loan, so you really don't have much to lose in terms of risk-reward. So let's talk about the 7 tips, and I call them profit pointers. Let's get into them one by one. And by the way, I see a lot of questions coming here, and I'll do question and answer at the end of the presentation. Okay, so deal analysis is number 1. What makes a good subject to deal? Because you'll find plenty of people who will do this with you. The question is, do you want to do it? And what's the analysis that goes into whether it's worth doing? One is this neighborhood desirable? Is this property desirable? Location, right? Is this something that it's a desirable property you can rent or resell? What's the condition of the property? What's it going to cost you to put it into rental condition if you plan on renting it, or resale condition if you plan on reselling it? Number 3, what are the terms of the loan? And I think this is a really, really important one. Is it fixed or is it adjustable? And if it's adjustable, what are the terms of those? Are there any back payments you have to make up? If the person's in foreclosure, you may have to make up 8 or 10 back payments plus default interest at 18% plus attorney's fees and costs. It may not be worth your while to do it. So if it's a couple of payments, maybe. But you have to balance these factors. Can you rent it or resell it? So if the guy's got a property in reasonably good condition in a desirable neighborhood, it's got a 3.5% loan, and which means his payment is below market rent, and there's no back payments or just 1 or 2, and the seller only wants a little bit of cash, and you can rent it, or you could fix it up and there's enough equity to resell it, by all means. And most importantly, what does the seller want out of this property? In most cases, it's going to be nothing or very little. Because in most cases, if someone's willing to walk, they don't have a ton of equity, okay? And they don't have a ton of options. By the way, where would you find deals like this? Who would we target who has low interest rate, very little equity, but can rent for more than the payment? Well, in a certain price range, FHA loans, VA loans, low down payments, usually don't have a lot of equity, or recently purchased homes with less than 20% down. You could target these things, but this is all public information. You can figure this out. You can buy lists of properties that fit this criteria. Profit pointer number 2, get the deal under contract before you waste your time or money. Gosh, I can't tell you how many newbies and beginners waste their time doing all kinds of research, all kinds of due diligence, spending all kinds of money without even having the deal under contract. Inked means signed by the seller. So let's look at that. Number 1, either use your own contract or the broker form that the brokers use with a good addendum. A standard purchase contract where you just add the words subject to existing loan is not sufficient. You've got to spell things out much, much clearer on your contract. Disclose, disclose, disclose. Disclose anything and everything, especially if you're a real estate agent. You better really disclose heavily The fact that you're an agent, the fact that you could list it and maybe get them more, the fact that you're buying it for under market, and why? Right. Why in the contract? I have a blank in my contract where it says the seller has tried other things, including, and I let them handwrite in what things they tried. So they can't come back later and say, well, I had other options. Well, they tried every option according to what they wrote in my contract. Number 3, be aware of foreclosure protection law requirements if they're in default or in foreclosure. So in some states, probably about, last I checked, it was about 18 states, there are foreclosure protection statutes that dictate what type of contract, what disclosures, and most importantly, a rescission period. So for example, in California, which is the state this all started in, you have to give the seller a rescission period. You must give them the right to rescind the contract for a certain number of days. Colorado, we have that too, but in Colorado, it applies not just in foreclosure, but as soon as they're 30 days behind. Now, how do you know that? You could ask them and they could lie. So we have to deal with someone who is potentially behind in payments as if they weren't telling the truth. Whereas California, and most other states, it only triggers when the person is in foreclosure, meaning a notice of default or a lis pendens has been filed, depending on what state you're in. So be aware of those things. And if they're behind in payments or in foreclosure, you got to deal with a certain type of disclosure and rescission. And make sure all authorized parties sign the contract. Gosh, I can't tell you how many times I've seen this, where someone doesn't bother to check who's all on title, or your state is a state which has community property, like California, where you need both spouses' signatures, even if only one is on the deed. And if the spouses are estranged, you're going to have to go ahead and find the other spouse and get them to sign it too. A lot of states have what's called dower and courtesy rights. That's not courtesy like being courteous. It's courtesy, C-U-R-T-E-S-Y. What it means is that the spouse has a right to the property, even though they're not on title, similar to community property, but just requires signatures of both parties. So just make sure you're aware of all authorized parties sign the contract. Profit pointer number 3, get copies of the mortgage. I'm just reading a comment. Yes, that is Jimmy Page's symbol on my coffee mug. Someone caught that. Zoso. Profit pointer number 3, get copies of the mortgage docs and read them. Gosh, you're going to take over a property. You're going to pay money. You're going to make up back payments. You're going to pay closing costs, and you're taking over a mortgage. Make sure you know what you're taking over. You could think it's a fixed rate loan and end up not being a fixed rate loan. Ask me how I know that. Because I didn't read. I took the seller's word for it. So read the docs. What is the interest rate on the note? Is it fixed or is it adjustable? If it's an adjustable, what's the ceiling? What's the floor? Read the terms of it. How much can it adjust? How often can it adjust? Is there a prepayment penalty? Let's say your plan is to fix it and sell it in 6 months. Is there a prepayment penalty that you need to be aware of? Is there a balloon? Not that common, but it's possible. There could be a balloon, an early maturity date, and you think you're taking this over for another 22 years and the note is due in 3 years. Is it FHA, which is not necessarily a problem? I've had people tell me that title companies will tell them that they can't do subject-tos on FHAs. They say it's illegal when there is no such law. And there's this wives' tale that's been going around for 30 years, that is maybe more, but I can remember for 30 years, that if a title company does a closing where someone's taking title subject to an FHA loan and HUD finds out, that they'll ban them from doing HUD closings. And that's just the funniest thing I've ever heard. I've never actually seen that happen. It's just an old wives' tale that's been floating around, and title companies, hear about it and they're afraid. So not all title companies will do a subject to an FHA. But if it is FHA and there is a co-sponsoring state program, in Colorado we have what's called CHFA, Colorado Housing and Finance Authority. It's like the state version of HUD. And what they do is they chip in for that down payment all are part of the 3.5% on the FHA loan, and they will call the loan. Their funds there are for low-income, owner-occupied properties. If the person moves out and rents it, they'll call the loan. If you take subject to, they will call the loan. So just be aware, if it's an FHA and you see another document in there, or it's payable to some state-sponsored housing authority, alarm bells should go off. That's the only time that I've seen lenders making it routine to call a loan due. Profit pointer number 4, do a complete title search before closing. So don't waste your time doing a title search until you have it under contract. Once you have it under contract, between contract and closing, do a complete title search, which means you want to identify all the owners. You should know who all the owners are by asking the seller. If you're in a community property state and they're married, get both spouses' signatures. But if you get a list of identify all the owners from the title records, then maybe you can go back and amend the contract if you miss somebody. Identify all the liens on the property as well. So there might be other liens besides this mortgage or deed of trust. There might be an IRS lien, a judgment, a second mortgage that you weren't told about. You know, all kinds of surprises do come up when you go ahead and, you know, do a subject to and then get the title search done. Look for foreclosure notices in the title search. So if it's in foreclosure, you know now that you have to deal with potential foreclosure rescission periods. You have to make up back payments and so forth. And check with municipal authority for other liens that don't show up on a title search. For example, if there's municipal water and sewer or other services that are municipal, usually they become a lien on the property whether they're recorded or not. So you should know those things from asking other investors, attorneys, title companies, and so forth in your area who deal in properties. They'll tell you what things to look for. And here's an important one. The property taxes, you're basing your estimation of this deal on property taxes being X. Well, in some states, if it's your homestead, your primary residence, you get a discount. Or if you're over a certain age, like 65, you get a discount, okay? If you transfer title now from the seller to you or your LLC, and which is now going to be a rental, no longer owner occupied, no longer a homestead property, your taxes will go up significantly. So make sure whatever property taxes you're assuming in the payment, assuming to be existing, that they don't change if you change the use of the property or change the ownership of the property. Keep that in mind. Okay, moving right along. Number 5, search bankruptcy records. Now, you should ask the seller, are you in bankruptcy? But they won't always tell you the truth, or maybe they're confused. So you could search them on pacer.org, that's the government website, for bankruptcy filings, and you look up your district, and you could search by name, social security number, case number, if you have one. Obviously, if they're telling you there's no bankruptcy, that's hard. But if they have a unique enough name, you have their middle initial, and you search maybe the last 2 or 3 years to find a case, you might find an open bankruptcy case. So if there is an open case, then you're going to need, especially if it's a Chapter 7, the trustee in bankruptcy's permission. So who's that? When someone files for a Chapter 7, which is a liquidation, they're going to list all their assets and liabilities on their petition, and the court appoints a trustee, which is someone who oversees the case, deals with creditors, deals with assets, and reports back to the court. If the property is in an open case, the seller doesn't have the legal authority to convey property because it belongs to the bankruptcy estate. I know that's a little far into the legal lingo, but to follow me here. The bankruptcy estate is under the control of the bankruptcy trustee. So you need the bankruptcy trustee's permission to release the property from the bankruptcy estate. And this is the lingo you need to know when you talk to the bankruptcy trustee. How do you know the bankruptcy trustee? When you look up the case on Pacer, it'll tell you the name and address and phone number of the bankruptcy trustee. So you'll go with the seller and to the trustee and ask them to release it. If there's very little equity in the property, they usually will do it no problem. But getting a hold of the trustee is not Easy, because trustees don't get paid very well. What if they file a bankruptcy after you close and took title? That's a question I get all the time. Shouldn't be an issue. The only time you have an issue is a creditor cries foul and says this is a fraudulent conveyance in bankruptcy. And that's only the case if you, the buyer, are, quote, an insider, which means it's your friend or relative, more likely a relative, and it's for less than reasonably equivalent value. Now, if it's a $300,000 property and you're buying it for $250,000 subject to a loan of $250,000, there's $50,000 in equity the seller's giving up. Is that market value? No, that's reasonably equivalent value. Reasonably equivalent value. And courts have said that 80% is reasonably equivalent. In that case, that's 80%, where you're within 80% with the equity. But again, it's not an issue that another creditor is going to cry foul unless there's a lot of equity and you're an insider, just FYI. So if they do file bankruptcy after you close, that's fine. Talk to the seller. Ask them if they're planning on filing bankruptcy or if they have any intentions to wait till after closing, or if they already filed, get the bankruptcy trustee's permission. Number 6, know your back end before you go in. You should know what you're going to do with this deal before you put it under contract. So what's the plan? Are you going to fix and rent it? Can you do that? That's fine. Are you going to fix and resell it? Well, that's fine. Probably one of the best options, because there's no chance on a loan being called within 6 months if you're going to fix and resell it within 6 months. So who cares? If you're going to fix and rent it long term, that's different. 5 years later, the lender could all of a sudden now get a new servicer who makes a stink and says, hey, you transferred it and we're going to call it. Not likely. Very low risk of that. But again, if you put a little bit of money down in terms of 2 back payments and a few grand to the seller, a little bit of carpet and paint, so let's say you're all in for $8,000, and you rent it for $5,000 a year positive cash flow, and in 4 years the lender calls it, you've already made your money, then some. Just give it back to the seller or negotiate something with the bank. A lease with option, that might be a good way to do it. So you lease it with an option to buy to a tenant buyer, and you get a short leash on that, 2 to 3 years, so that that tenant buys it from you and you pay off the underlying loan, and no harm, no foul, right? A wraparound sale. So you could sell it on, let's say, an all-inclusive trust deed or wraparound mortgage or installment land contract for deed. Very profitable, very powerful tool. I don't want to get too far into the weeds with that type of sale, but just those of you who know what that is, that's a possibility. And what if the loan does get called due? What's your exit plan? You should have that contingency, so you can sell it and pay off the loan, refi and pay off the loan with a lender who could care less, bring in a partner to pay off the loan cash, ask the lender to waive the due on sale, ask the lender for more time. I'm going to tell you a story. I had a client who did a subject to, just rented it out. About 3 years later, the seller came back and said, wait a minute, this is still on my credit report. I thought you were paying this loan off. And my client says, I never promised you that. I said I was taking subject to. Now, obviously, the seller didn't understand, and my client didn't explain it very well, and his disclosures were terrible. So the seller says, well, when are you going to pay it off? And my client said, when I feel like it. Wrong answer. Now, he's right legally, but when you're dealing with a difficult customer, that's not the way you do it. What he should have said was, how much money do you need to make this go away, make this not a problem? And I bet you if you gave him $1,500, the guy would have been thrilled. But he didn't. He was a wise ass. So he comes to me and says, what do I do? I said, first of all, schmuck, that's not how you deal with a difficult customer, right? There's a right and a wrong way. You did it the wrong way. He goes, all right, what do I do now? I said, well, what are your options? He goes, well, I could refi it or I could sell it and pay off the loan. I said, all right. He goes, but the bank gave me 30 days to do it. I can't do it in 30 days. I said, that's not a problem. I said, let me write a letter to the bank and ask them for more time. So I write a letter to the bank and I said, dear bank, we got your letter. You're right. It was transferred and you're calling the loan due. We request that you give us 6 months to pay it off. Okay, so that'll give them time to sell it or refi it or whatever. So 3 or 4 weeks go by, don't hear anything back. Try to make a few phone calls, couldn't get through to anybody. So I told my client, you better go deal with this right now. So he goes and sells the property a month later, pays off the loan. 6 months later, I get a letter back finally from the bank. The answer, no. No, we're not going to give you 6 months. Took him 6 months to say, no, we're not giving you 6 months. So that was one of 2 times I said the loan got called on a deal that I was aware of. But it's unusual, but it does happen once in a while. But, stranger things. And finally, number 7, get the seller to sign comprehensive disclosures and a power of attorney. Now, before I get to that, let me explain something to you. It is good practice not just to shove disclosures under people's noses and say, initial sign, sign. It's a good practice to explain to them in plain English what these things mean. You don't want to just shove it under their nose because they'll pretty much sign anything if you're giving them money and bailing them out. It's later when they come back and go, I didn't understand. So it's a good idea to have these things signed. Should you tape record the closing maybe? Yeah, I'd say so. Get their permission, record the closing. Why not? Maybe even videotape the closing. Maybe even get them on video saying, I understand X, I understand Y, I understand Z. Why not? It's good evidence. So here's what you want to make sure is disclosed carefully in the contract and again at closing. Number 1, they understand about the due on sale. Now, oddly enough, most sellers are not problematic with the due on sale. They understand that this is some big bank halfway across the country that's not going to call a loan, could really care less. And frankly, in most cases, the seller could care less because if they're going to get some money and they were going to walk away anyway, what do they care? It's not their problem anymore. You should make it abundantly clear that it remains their primary obligation. Okay, so if this thing goes bad, it goes on them, not on you. It still reports on their credit. So if they go to get another loan for a car or a house, they're going to have to explain that they've got this obligation and how it's being dealt with. Number 4, they cannot deduct the mortgage interest anymore. Now here's what's going to happen. The bank, who still thinks in their computer system the former owner is the borrower, which he still is going to send them a Form 1098 every year. In the past, they may have been deducting that mortgage interest on their taxes. Well, if they no longer own it, they cannot deduct the interest anymore. Can you, the buyer, deduct the interest? Well, the requirements under the Internal Revenue Code and the cases and the, what are they called, the regulations, don't say that you need to have a Form 1098 in your name. There's 2 requirements. 1, you own the property, and 2, you made the payments. That gives you the right to deduct it. Remember, you're not deducting it unless you're living there on your personal return. You're deducting it on, well, if it's a rental, maybe you're deducting it on your Schedule E or on an LLC tax return. And of course, that they are giving up any equity they may have in the property in exchange for whatever you're doing for them. Very important. And most important, a lot of people overlook this, that they are waiving the escrow account. If there's an underlying impound for taxes and insurance, when the loan is paid off, there's usually anywhere from $600 to $1,500 in that account, and they're going to write a check to the former borrower in his name. And what are you going to do with that? Well, he's going to want to cash it, but if he waived it in writing, it's yours, but how do you cash the check? How do you cash the check? Well, I said earlier, get a power of attorney at closing. A limited power of attorney that gives you the right to deal with his lender, his insurance company, make any claims, to deal with any title issue, to cash any checks, and so on and so forth. So you get a specific form called a limited power of attorney that allows you to deal with that. And it's very common that the seller's lender may change servicers on you and then miss a payment, and now you call them up and say, hey, you're missing a payment here. You can't get a hold of the seller. And they're like, who are you? We can't talk to you. We can only talk to the borrower. I've got a power of attorney. Give me your fax number. I'll fax it in and then call them back in 2 days, and they don't still have it. Fax it again. You know how the game is, some of you. But it gives you the power to deal with those little loose ends. Okay? All righty. Let me take a few questions because we have a bunch. Let's see. This is Denise. Where can I get a holdover occupancy and a cash for keys agreement? Email me, Denise. I might have what you are looking for. bill@bronchick.com. I'll post it in the comments, my email address. There you go. Jeffrey asked, will this be available as a recording? No, it's live. You have to attend live. Just kidding. It's on YouTube. It's streaming. It'll be available right after we are done on my YouTube/Bronchick page. Matthew writes, oh, that's just a comment, not a question. Thank you for clarity and intelligence, Bill. Well, thank you so much. I appreciate the comment. Who gets the tax write-off, Thomas asks. I think we just covered that, Thomas, but whoever owns the property, whoever makes the payments from there on is able to do that. Stanley asks, would they still be able to get a tax credit? I think you're referring to the deductibility of the mortgage interest there, which we've just answered. If you're asking whether or not they can still get their exemption from capital gains taxes on this sale, the answer is generally yes, if the gain is less than $250. DeAndre Anderson asks, I noticed that the subject-to contract, I think you're referring to mine, needs to be notarized. How can I make this easy for the seller? Should I call a mobile notary to come over to the seller's house? I'm in Florida. My contract, I have a place for a notary. It's not required by law. It's a good practice to have a neutral third-party witness and have it notarized. And yes, you can call a mobile notary. If you go to It's Notary 123 or 123 Notary. I don't remember. I always get those two backwards, but I think it's 123notary.com. You can get a mobile notary for $75. We'll just show up at the house when you want and notarize a contract. There you go. Easier enough. Easy enough. The Average Wonder says, you would get the tax credit since you are now making the payments. Correct. Correct. The Average Wonder says, I have a question about insurance. I had a few people tell me that might be considered fraud for you to get a second policy under your name. In Florida, do you know a subject-to lawyer here? Two questions. One, the existing insurance policy, once you transfer title, is void because there's no longer an insurable interest in the seller anymore. Okay? So what you have to do is you have to change the existing policy to be the new insured, which is you or your LLC or wherever you take title in a land trust, whatever. And now you have it insured. Now, maybe that insurance company doesn't do rental policies, so you have to get a new policy. Now, what a lot of people do is, since this is a headache, they just buy a second policy. And the old policy is void as to claims on the house, but it's valid as to the lender. If it burns down, the lender still gets paid, but the homeowner doesn't get paid his equity. And the homeowner in this case now is you, because you're not a party to that insurance contract. Some people buy a second insurance policy that names you as the owner or your LLC, whatever, but doesn't name the lender. So if there's a claim on the property, you make it under that policy. If the property burns down and the lender needs to get paid off, it's paid off on the old policy. What you're asking me, is that considered fraud? No, absolutely not. You can get a policy in your own name. You didn't sign a mortgage obligation that you'd put the seller's lender on there as an additional insured or lien holder insured. So it's perfectly within your rights to do that. And the question is it cost effective? In Florida, certainly not, because insurance is expensive. But in Oklahoma or Iowa or wherever else, if you're dealing with a cheaper property and a cheaper policy, it might be just easier just to get a second policy. Do I have a subject-to lawyer? You know, my brother Ken is a lawyer in South Florida, and he has a title company. His name is Ken Bronchick, K-E-N, Ken Bronchick. You could look him up. He's been practicing law longer than me, and he's done 1 million closings, and he will do subject-to deals, and he will do them remotely as long as you're not too big of a pain in his ass. All right. One question, and I'm going to go on. Subject-to contract does not need to be notarized. That's correct, Jeff. Denise asks, what is the best equity to pursue a subject to foreclosure? 40 to 20%? I don't think there's a solid answer to that, Denise. As I said in my first point, analyzing the deal, you got to balance a number of factors: equity, desirability, how much work it needs, how many back payments, what's the interest rate, what does the seller want. So it's not 40% equity, 20% equity. Honestly, if the loan interest rate was low enough and it was far below market rent and I could rent it for positive cash flow, I'd take a property that was upside down subject to. I really would. And I've done that before on loans that were modifications. I had this one seller who modded a loan down to 2% for the next 5 years. And I took it subject to upside down by 15 grand. I didn't care because I was getting positive cash flow from the rent. And then eventually the property went up in value and it right-sided itself. So not really that big of a deal. Not really that big of a deal. All right, before I forget, I wanted to tell you about my Buying Property Subject To course, which you can get on LegalWiz.com. Click on Store. And this is an e-course that includes a PDF course manual with instructions and checklists, online streaming videos of me explaining everything, downloadable audio, legal forms and contracts with all the disclosures you need, valid in all 50 states, negotiating tactics. And by the way, in addition to legal forms and contracts, I have addenda that you could stick on to a standard broker agreement if you want to use your local broker agreement, or if you are a broker or an agent and you want to use your realtor contract and then stick an addendum on that. I have addenda included in that course. Okay? So that makes it valid in any state, because if you're in North Dakota, you just use the North Dakota realtor contract and use my addendum, and there you go. So negotiating tactics, how to negotiate a subject to the seller, how to answer the common objections, how to handle it. Very, very important. I think most people blow it on this. They blow it. They don't know how to negotiate it. They don't know how to explain it. And I have a video in the course that explains my contracts. So how to fill them out, how to calculate the numbers, how to fill in all the blanks. So it's step by step. It's a paltry $397, ladies and gentlemen. I charge $1,500 for a closing, just one closing. For $397, you get everything that explains it, how to do it, the forms, the contracts, everything for $397, but there's even more. So if you use the code CURE, C-U-R-E, on LegalWiz.com/store, you can find my Buying Property Subject To course, as well as 15 others. Actually, no, I think it's 18 total, so it's 17 others. You can use the code CURE for 60% off this or any other course on that website. So go to LegalWiz.com/store, and you will find the Subject To course. And when you check out, use that code and get your discount. I'll put it up here so you can see the link. Okay, let's go back to questions. Llama says, I had a former partner where she did force the bank, as the house was bought at auction and taken subject to the second mortgage, and she got the bank involved. He lost case in a lawsuit. I have no idea what that means. I guess this is a further explanation of that. My first subject to deal, the attorney for the buyer claimed, as you state, that you can't take it subject to because it was a state-backed loan, and because of the bond regulations, they would call the loan due. Yeah, that is a state-sponsored FHA type loan, which you have to be aware of. Denise asked about the insurance. I think we already covered that. Philip says, look for other interests in the property, like children from other marriages. Well, that would be like if the seller has a life estate and there's a residual to somebody else. But if it's in a will, it doesn't really matter. Lama asks, what state do I live in? I'm in Colorado, Lama. I'm in Colorado, and I do subject to closings and contracts and things here in Colorado. Lama says, different market in LA. Of course it's a different market in LA. LA is a different market than Denver. Denver's a different market than New York. It's a different market than Miami. But subject to works all day long in LA. And you're going to have some people suffering who can't make payments in LA, who are going to need this strategy to help you solve their problem, Lala. So not a problem. Much more red tape compared to Virginia. I'm not in Virginia, but California is the one of the most highly regulated states. But in terms of subject-tos, the only thing you got to be aware of is that foreclosure consultant law in California, which gives the seller in foreclosure a rescission period if you buy subject-to. But you can do those in California. Okay, here. Insurance, a lot of the same questions. Insurance issue. What is my average term on a subject-to, John asks. When I buy for good. You know, I take subject-to for good, so I can do whatever I want with it forever. That's what's disclosed in the contract. Now, occasionally a seller says, well, I don't want this hanging out there forever. And I'll put a clause in the contract that says this survives closing, but I promise as the buyer to pay off the loan within X years. And I've done that before. And then went back to the seller after 5 years and said, you know, it's just working out fine and I don't want to get a new loan and I don't want to sell the property. How about I just give you $1,500 and we'll let it ride the rest of the term of the loan? I had one that was a 15-year note. I took the subject-to with 11 years left. I promised to pay it off in 5. So we're down in the last 6 years, and it was ridiculous for me to refi it at that point. So I just gave the seller some extra money, and she was okay with it. She was okay with that. Oh, this is a good question, a good point. Alana mentions, I noticed in subject-to people recommend sending a certified letter to the lender informing them of the subject-to, as opposed to saying nothing. Gee, you know, what's the point of sending a letter and alerting them? Well, the point is 5 years, 10 years later, they come call the loan due. There's a defense called latches, L-A-C-H-E-S, latches. What does that mean? That means you're asking the court to rule that the lender has waived the right by not enforcing it, use it or lose it. That's what latches means. So the question was, did they have notice? Well, the deed transferred in public records, that's notice. They get a copy of the insurance change if you did that, that's notice. And you're sending payments in a different name unless you're doing it online directly, you know, through a automated payment, they wouldn't have notice. But some people say, well, let's give them explicit notice. So 5 years later, or 10 years later, they come to call the loan due. We could say, aha, judge, we gave them notice and they did nothing and they can't enforce it now. There's some validity to that argument. But the question is, do you want to write a letter alerting them? And now it depends on who you sent it to. If you send it in with your check every month, you know, dear bank, here's my check for May. And by the way, I'm taking this property over, and sort of daring them to do anything. The person opening the mail doesn't know anything about due on sales. So I don't even think that's good notice. You'd have to write it to like a branch manager or an executive vice president for that argument to even work. So I don't know if that's even necessary. Stanley, you're so amazing. Thanks, Bill. Thank you. It's my pleasure. Well, John asks, this is what we call chutzpah. If you don't know what that means, that's a Yiddish word for yavos or huevos. What about doing a loan modification on a subject-to so the mortgage payment works in the green? So let's say the seller is 4 payments behind. You get the power of attorney. You negotiate for the lender to not only waive those back payments and add them to the back of the loan, but to drop the interest rate and then take it subject-to. Boy, that's chutzpah. Because the presumption here that you're giving to the bank is you're working for the borrower for a deal that they can have to live in the house that you're about to take subject-to. I wouldn't say that's fraud, but boy, if they caught on. I can't say Can't say I've never done it, but I don't want to go into details. But I wouldn't make a routine habit of that. The average wonder again writes, I already bought your course, great value, especially with the code. Thank you for your knowledge. Thank you very much. Thank you. Jim asks, I guess the moot point, do you have a contract document package you will give away or sell? Sell. See right there on the screen. You see it there? LegalWiz.com/store. Mark asks, how many disclosure documents do you get in the course? What type of disclosures are they? I have two sets. I have a contract with disclosures when they sign, and then I have another set of disclosures I give them to sign before a notary at closing, and they're pretty comprehensive. They're pretty damn comprehensive. Philip asks, any issues in taking ownership into the real estate in a privacy trust, you mean like a land trust? Does this reduce the likelihood of the due on sale being called because of the Garn-Germain Act? The short answer is, I think so, but the more complex answer is, I really don't think they give a rat's ass. Whether you take it in a land trust, your own name, your uncle's name, and an LLC or a corporation, if they're going to make a stink, they're going to make a stink because the interest rate on the market is 11% and the loan is 4%. Other than the example I gave you before about a state-sponsored loan, maybe this was a seller carry loan you took subject to that someone doesn't like, or a relative lent the money as a second on the property and now is going to make a stink. Major banks just haven't seen it. I really just haven't seen it. Okay. All right. Thank you for all participating. Wow, that hour went by quick. I said 40 minutes, but you guys had great questions. I'm going to wrap it up with that. If anybody has any more questions, I'm going to I put my email in the chat thing that you could see, but I'll also put a direct link to my website and to make sure you have it. And use the code CURE. I'll put that in there so you can just click on that link. You might be able to click on the link right there on the bottom on the ticker tape thing that's going, but I have no idea. I haven't used this that much. But thank you for joining me. I appreciate the questions. I appreciate you taking your time on a Sunday evening to watch with me and learn some new ideas. And I hope more than anything, you've learned something that you can put this into action. And now you have the confidence to put this into action. Thank you very much for joining. Watch the replay. God bless.